Companies Act Section 129 Financial Statement, Preparation, Compliance, Presentation, and Consequences for Non-Compliance. Section 129 of the Companies Act, 2013, lays down the statutory obligations regarding the preparation, form, content, and presentation of financial statements by companies. The intention behind this section is to ensure that every company's financial health is presented in a true, fair, and transparent manner, enabling shareholders, regulators, and stakeholders to make informed decisions based on reliable financial data. Requirement to prepare financial statements. Every company is mandated to prepare financial statements for each financial year, which must meet the following essential criteria. 1. True and fair view. The financial statements must present a true and fair view of the state of affairs of the company or group of companies, where applicable. This means the statements should accurately represent the assets, liabilities, financial position, and operational results without misleading or concealing any material facts. 2. Compliance with accounting standards. All financial statements must comply with the accounting standards notified under Section 133 of the Companies Act. This ensures uniformity and consistency across companies in the presentation of their financial information. 3. Form and format. The format and structure of the financial statements must conform to the forms prescribed under Schedule 3 of the Act. Different classes or categories of companies may have to follow separate formats, as specified. Exceptions for certain companies. This general obligation does not apply to certain specific types of companies, which are governed by sector-specific laws. Insurance companies governed by the Insurance Act, 1938 and Insurance Regulatory and Development Authority Act, 1999. Banking companies governed by the Banking Regulation Act, 1949. Electricity companies engaged in generation, transmission, or supply of electricity, governed by the Electricity Act, 2003. Other companies governed by special laws. Any other class of company for which specific financial statement requirements are prescribed by any other law applicable to them. For these companies, financial statements are considered compliant even if they omit certain disclosures required by the Companies Act, as long as such omissions are permitted under their sector-specific legislation. Laying of financial statements at Annual General Meeting. At every Annual General Meeting, AGM, the Board of Directors of the company has a statutory duty to formally lay before the shareholders the financial statements of the company for the relevant financial year. Consolidated financial statements. If a company has one or more subsidiaries or associate companies, it has an additional obligation to prepare a consolidated financial statement, CFS. This consolidated statement must be prepared in the same form and manner as the standalone financial statements. Follow the same accounting standards applicable to the main company. Be presented at the AGM along with the standalone financial statements. Additional disclosure, salient features of subsidiaries associates. Along with the consolidated financial statement, the company must attach a separate statement summarizing the salient features of the financial position and performance of each subsidiary and associate company in a prescribed form. Government power to prescribe consolidation rules. The central government has the authority to prescribe detailed rules regarding the consolidation of financial statements. These rules may define manner of consolidation, exemptions, if any, treatment of jointly controlled entities, application of holding company rules to consolidated statements. All provisions of the Companies Act that apply to the preparation, adoption, and audit of a company's standalone financial statements also apply mutatis mutandis to its consolidated financial statements. This ensures uniform governance standards for group-level reporting. Disclosure of deviations from accounting standards. In case a company's financial statements do not fully comply with the applicable accounting standards, the company must make specific disclosures within the financial statements. These disclosures must clearly state the specific deviation from the applicable accounting standards, reasons for the deviation, financial impact of the deviation, if any, on the company's reported financial position or performance. This ensures that shareholders and regulators are fully aware of any departure from standard accounting practices and can assess the potential consequences of such deviations. Exemptions for certain classes of companies. The central government has the power, either on its own motion or in response to a formal application by a class or classes of companies, to exempt such companies from complying with any part of Section 129 or the rules framed under it. Such exemptions can be granted if it is considered necessary in the public interest and either unconditionally or subject to specified conditions as mentioned in the notification granting the exemption. Penalties for non-compliance. If a company fails to comply with the requirements of Section 129, the following individuals can be held personally liable: Managing Director or Whole-time Director in charge of finance or Chief Financial Officer, CFO, or any other person specifically charged by the board with ensuring compliance. If none of these positions exist or have been designated, all directors of the company become liable. Punishment. The penalty for non-compliance includes imprisonment up to 1 year or fine not less than 50,000 rupees, but which may extend to 5 lakhs rupees, or both imprisonment and fine, depending on the severity of the violation. For more details, contact us.